e te whakamenenga. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Lecretia, hoki wairua mai ki tēnei pō whakanui i a koe, me o mahi i ngā tau ki muri nei. Ko tō whānau kua tae mai hei whakakanohi i a koe, nō reira ka tītoko ko te ao mārama kia tātou kua pai nei, kua tātū mai nei ki te kauhau o tēnei o ngā aho nuku o Te Herenga Waka, uri no Te Rauhī a Māmari Stephens. Nō reira kei aku nui, kei aku rahi, tēnā koutou, tēnā koutou, tēnā koutou katoa. Friends, colleagues, students, welcome to the 2025 Lecretia Seales Lecture in Law Reform. My name is Professor Rawenia Higgins, Deputy Vice-Chancellor Māori and Kaitiakitanga, and it's my privilege to welcome you here tonight for what I know will be a very thought-provoking and informative lecture. I want to especially acknowledge and thank the whānau and friends of Lecretia Seales. Your continued support for this annual lecture keeps her legacy alive in a way that truly matters, not just to the legal profession, but to all of us who care about justice and meaningful change. Tēnā koutou. Tonight we gather to honour that legacy and to continue the important conversations she helped to ignite in the legal profession. It is my great pleasure to introduce our speaker this evening, Reader Māmari Stephens. He wahine nākou nui ki ana mahi, he wahine nākou nui ki te tangata. Māmari, who has been with Te Kauhanga Nui Tātai Ture, the Faculty of Law since 2006, has a long-standing interest in exploring what mātauranga Māori can add to our understanding of law in Aotearoa. I'm sure many of you are familiar with Te Kaupapa Reo Āture, the legal Māori project, which Māmari led alongside Assistant Professor Mary Boyce, formerly of the University of Hawaii. Te Kaupapa Reo Āture led to the creation of a number of valuable resources that help speakers of Te Reo Māori use Māori vocab to describe Western legal concepts. These resources include the first dictionary of Māori language legal terms, He Papakupu Reo Ture, and the online legal Māori resource hub. Māmari is now leading the research project Te Rauhī I Te Tikanga, a Tikanga Companion, which is generously funded by the Michael and Susan Boren Foundation. On behalf of the University, I would like to thank the Foundation for its ongoing support of this fantastic initiative. This project involves gathering and analysing sources that reveal the practices and principles of Tikanga Māori as a coherent system of law. In this lecture, she will discuss the innovative Māori legal research methods that have been developed and how this research can help transform legal education in Aotearoa. I know I speak not only for myself in saying how honoured we are to hear Māmari speak tonight and to hear her insights into Tikanga Māori as a legal system. Before we begin tonight's lecture, I would like to take a moment to note that this year marks the 10th anniversary of Lecretia's passing and acknowledge her whānau and friends once more. Only through their generosity and continued support can Te Kauhanga Nui Tātai Ture, the Faculty of Law, host this important annual event and honour Lecretia's legacy. The University is keen to work with those who donate to kaupapa such as this, and if you are interested in supporting, please feel free to reach out to any of us. Hoi anō, nōku te maringa nui, kia tono atu ki tēnei o aku tuakana a aho nuku Māmari Stephens. It is my pleasure to now welcome our speaker for the 2025 Lecretia Seales Memorial Lecture in Law Reform, Reader Māmari Stephens.
Kua ki te ruma nei. Titira atu ki ngā Māori kei murira. Kia ora! Ka nui te mihi kia koutou, rauranga tirama, kua tai mai. Ko ai tēnei he uri tēnei no Te Rauhī, ko Ngāti Moitonga me te roke kā, aku hapu. Ko wainui te marae, ki te tohu tōku pāpā ko Te Rauhī tēnā, ki te tohu tōku taha o tōku māma ko Ngāti Airihi, me ngā kotimana hoki tērā, nā reira. Ka nui te mihi kia koutou tuku whānau, taku hoa, tāne a Maina, aku tamariki a Haviland, kōrua ko te rangihuia, te whānau whānui. Engari, ka huri ahau ki te whānau o Lecretia. Ka nui te mihi ki a koutou. Hari ko te ngākau ki te tutaki ki a koutou. He hōnore tino nui tēnei māku. I'm really grateful to be able to acknowledge Lecretia in the presence of her family, along with the presence of my own family. We're not much without the people who formed us. And the people who formed Lecretia and what she was able to achieve are here tonight, and no doubt she formed you too. And these people, for better or for worse, helped to form me and I them. So it's a wonderful thing to be able to give a public lecture and to feel so connected, not only with family, but with students and old bosses and just people that I love here. So, kua ki te ngākau i te harikoa, tēnā koe rawania, mua kupu whakanui, reka hoki, kia ora. Okay, well, these photos, I took the one on the right on the weekend, the one on the left I pinched from Facebook. These are the part of the exposed Kumutoto stream. So I think this is near Kelburn Park, where you can see when the storm waters are up, you know, the body of the stream flowing free. And this area here is the outlet by the Ngā Kina sculpture, which is where Te Kumutoto comes out into the harbour. And I thought about this as an image, this idea of a fully functioning stream, part of a fully functioning water system. The first culverted stream in Wellington, many people will know that here, kind of encased in concrete for most of its journey until it's released into the harbour. But of course, it's not just Kumutoto. There's something like 700, I'm going to say kilometres, I'm not sure if that's true. But anyway, lots and lots of streams in Wellington that have been culverted. And in fact, if we look on the next slide, I probably can't see this. This is a Wellington water map from 2021. You've got your blue natural streams, and then the green, you can see them, that's the culverting, right? That's the kind of encasing the stream. So the streams are hidden from view. They run under our feet. They run under the streets. If you see a drain and it says empty straight, will go straight to the ocean, that's a stream down there, right? But I don't think I ever thought that until the weekend. Like, that's how recent my understanding is, that we have beneath our feet this incredibly complex system that we barely ever see. And the bits we can see have E. coli in them, right? We all, if we're living here in Wellington, we all know the problems we have with water. So I thought that made a good image of the existence of a system out of mind, mostly out of sight, out of comprehension, built over and accreted over, and kind of, it would prefer you not to think about the waters that fly underneath or that flow underneath, but they're there anyway. And we know they're there. They have wildlife in them. The banded kōkōpū still swim in them. Freshwater crays are still there. There's all kinds of good things that happen in those streams, even though they're hidden from our mind's eye and our actual eyes. So I thought that was a really good analogy for Te Kao Māori as a Māori legal system that has existed for a very long period of time, many centuries, that has been accreted over and hidden from so many people's views, hidden from so many people's understanding, actually. That's not anyone in this room, it's not their fault, right? I'm not here to be laying blame about this, but it is something to be cognizant of, that there is something happening that most of us are hidden from, or that is hidden from most of us. And so, with the generous support of the Boren Foundation and Pilotu's here, kia ora, mate, with which we couldn't be doing this for the last couple of years or so, we have sought to demonstrate a hypothesis, and it's nothing new, right? There's lots of people in this country that could tell you about the nature of the Māori legal system. There is nothing groundbreaking in the fact that there is a Māori legal system, and we call it Tikanga Māori, but it operates as a legal system and all kinds of things as well. But what we wanted to do in this project is to demonstrate the core legal norms that can be articulated in Tikanga Māori and that drive the implementation of a set of legal practices and procedures. That's not revolutionary. But what we wanted to do was to begin to kind of see that as an operating whole system. And one of the reasons there are so many students here tonight is that most of them are research assistants in that project. So they want money now. And I can't tell you how grateful I am to all of these people and to Ria and to Harvey, to all those people that have been involved. Because we've kind of from the beginning been going, what the heck are we doing? How are we going to do this? Because there's such a lot of information about Tikanga Māori. It's massive. So how do you organise? How do you categorise? How do you make sense of this extraordinary amount of information in a way that can work for other people to learn about too? So this was just a couple of photos of the Kairangahau team. The only thing I want to say here on this slide really is that one of the things, and Ria and I talked about this yesterday. Ria, where are you, Ria? Oh, sorry, there you are. Ria's our head researcher. And one of the things that we talked about yesterday was just how important the researchers are in this process. Like, I've been quite distant this year. I've got a whole bunch of teaching, a whole bunch of admin. So, I'm here talking about it, but these are the guys who are actually doing the work. And one of the things that Ria said that really struck me was learning that it's okay to be wrong sometimes, right? Because none of us was a tikanga expert. None of us is a tikanga expert. And when we're dealing with the gathering and the analysis of sources about tikanga Māori, one of the hardest things is to show your vulnerability in front of other researchers, right? To show that you don't know something and you might have it wrong, because inevitably this is a process of wānanga, of collaborative learning, collaborative critique of the group, and collaborative kind of copying the results as well. So that idea that it's actually okay to be wrong and to admit that you're wrong, and also learn to fight for or stand up for what you think is right, and understanding how tikanga is operating as a legal system. These guys have been through all that. And I'm just incredibly grateful for how they've allowed space for me to be wrong too. That's actually really a key part of it. So, ka nui aku mihi kia koutou, kore mutu he mihi kia koutou, tēnā koutou, kia ora. All right, so one of the places to start is to begin to map, if you like, tikanga Māori as a system of law. One of the things we thought about was, well, what are the dimensions of human life, right? Social, economic, kind of the dimensions of life. So we come up with some dimensions, and we were thinking about, well, right, how do we, again, it's about channeling and controlling information so that at the end it makes sense. So how do we start with the manaakitanga, kaitiakitanga, mana tapu? Do we start there? There is so much information there. There is libraries full of information there. So we thought we'd flip that on its head a little bit and actually start with what people do on the ground. So operate in these kinds of spheres. What is it that there are certain, what kind of practices, not an infinite variety, but a set of practices and procedures that we can learn from the ground up. I remember the day we made that decision. Carwyn, you were in the room there, and it was like, yes, actually that sounds doable if we start from what we can observe, and then from there look at how the norms, the great norms that define Māori law, operate to drive these practices. So these are the practices. There's 12 of them, and we're pretty much finished with some rats and mice and a few bits and pieces to fill in of the gathering of those sources for all 12 of these practices. And of course, there are practices not on there, right? This isn't about being comprehensive. It's not about being exhaustive. It's about trying to demonstrate the functioning and the operation of a system. So we'll talk a little bit tonight about muru. So muru is kind of a process that involves the stripping of property, the stripping away of property as a kind of, to put it really kind of broadly, as a compensation for something that's gone wrong or something that's been done wrong, right? We'll talk more about that shortly. Rāhui, many of you will be familiar with, the temporary prohibition placed on areas, and for example, in cases of death in the water or for conservation purposes where shellfish beds have been undermined or not flourishing. If anyone from Ahipara here, we're in the middle of these debates right now about what to do with our rāhui up there. Ohaki, the idea of statements made before death, sometimes disposing of property, sometimes being instructions for people to live by. So one ohaki that we live by in Ahipara and in Te Rauhī is kia au ki te whakapono kia aroha tētahi ki tētahi. Hold to the faith or hold to truth, love one another, which was the ohaki of Pōroa. So there's lots of examples of ohaki. Pana, we'll mention this briefly today as well, expulsion. So expulsion of individuals who've done something wrong and broken, have committed some kind of hara. Tangihanga, many of you will be familiar with that, around the rituals around death and mourning. Huirunanga, the idea of decision-making gatherings, incredibly important, and with often very specific purposes. Whāngai, adoption, bringing in other people into the whānau who may not be your direct kin, but kin from other means. Aukati, borders being placed to help prevent the outbreak of war. Sorry, this is very kind of once over, but just so you get a sense of the spread of work that the team has been doing. Raupatu, land confiscation, rongo, peacemaking, hoko and tuku, the idea of property, exchange of property, and also the cession and the provision of land, gifting of land. A hākari, feasts, so much more than that, right? All of these have this incredible richness, but I think it kind of covers relatively well those dimensions of social life, social, economic, and other forms of life that most human beings adhere to in some way. So things we've noticed, and these are just very broad brush observations in the process of gathering these sources and analysing them. So that would require, kind of cataloguing them, dating them, figuring out who wrote them, what bias exists in the source, identifying the kind of lens that people are writing these accounts with, so that you're clear on what you have. What are the precipitating events that led to the implementation of these kinds of processes, and describing the stories, describing what's actually gone on, all that kind of stuff is what the researchers have been doing, and that's just scratching the surface. But there's been a few general observations, which I think there's lots more, but just for the purpose of tonight, gatherings are legally necessary for most of the ritinga that we examined. These things have to be done and witnessed by groups, right? Not all the time. Not all the ritinga require group-based process, but participation, transparency, openness, all that kind of thing is highly necessary for the majority of the ritinga that we've looked at. The ritinga and the norms seem broadly recognisable across people groups and geography, right? Which actually makes sense, because that's what you would say about te reo Māori. Te reo Māori is broadly, mutually communicable across the whole of the country with obvious variations. So there are obvious variations when it comes to tikanga as well, but these are broadly recognised practices and broadly recognised norms, actually, when we get to it. Birth status matters in the legal Māori system, and of course that has to evolve and change over time. Oh, I've seen you, Harvey. Yay! But birth status makes a difference to legal consequences. Risk management is crucial. We'll see an example of that tonight. And adaptation and change under external force. So many of the processes that we've looked at in our research, some of them are no longer extant in the same way that they would have been in the 19th, 18th, 17th centuries. However, a bit like the water system, right? One sentence that I read from the Wellington Water Report was something about the water system is degraded and a bit broken, right? So tikanga Māori as a legal system in parts is, and I mean by degraded, I'm meaning that there's been a whole lot of rubbish put in there, or that it's not been able to flow to its natural potential. So there are bits and pieces of this system that are not performing the way that they are, and we've lost some of the manifestations of these practices. But they haven't died out, right? There is an adaptation and change. Mostly these things survive. So then thinking about and you'll be familiar, if you've had a passing interest in anything Māori, you will have heard words like mana, tapu, utu. If you've done first year law in Victoria, you'll be familiar with these concepts because we teach this now as a part of first year law. So, and again, you can't really boil these down to one word definitions. I'm not going to try, but kind of the idea of mana encapsulating things like authority, things like prestige, value, worth in human beings. Tapu, the idea of the prohibition of certain things for particular purposes, the setting aside of certain things. Noa, making something free from prohibition. I don't need to go through all of these, I don't think. But a couple that I will mention, because they'll come up shortly. Utu, the idea of a response to something that's happened, right? Usually an equal and proportionate response, not always, but the idea of a response to something that's happened. Whanaungatanga, we'll talk about this shortly, the huge value placed on obligations of relationship. And manaakitanga and kaitiakitanga and manaakitanga. Well, actually, one of the points I'll make in the next slide here is that things we've noticed along the way, and again, these are just broad brush observations, is that the way we use these words today doesn't quite communicate how hard these norms are, how costly they are to uphold. And that's really important to remember because in ordinary parlance, it's really good to, exercise manaakitanga, show hospitality. That's absolutely true. There's nothing wrong with saying something like that. But when you're talking about manaakitanga as a legal norm, actually there are standards you've got to apply or adhere to. There is cost to your people. There is cost to yourself if you fail to uphold those standards. These are not easy obligations, these norms. Their full application requires and builds social cohesion. So just to give you an example, which I was thinking about yesterday, back here in the practices, hakari, right? Many of you may have been to a hakari, like a feast, yeah? Go to a wedding, have a big feed. Go to a tangi, big feed on the final day. There's all kinds of reasons for hakari. So, you might be comfortable in thinking of hakari as just an occasion to eat a lot of food and be merry. It's great. However, when we're looking at hakari in certain forms in the 19th century and before that, these are massive undertakings built on platforms many, many metres high. And what I think struck us when we were looking at hakari as a legal process was you might have to have up to 2 years of harvests in order to have the food ready, in order to be able to parcel it out to people who come to your hakari, and then they have to turn around and do the same thing because the size of the hakari determines the nature of the required utu, the response depending on the context, of course. That is not easy. You're talking about 2 years of harvests, maybe more, 2 years of preserving birds, you know, all kinds of things. Like, this is not easy to live by. And so sometimes these concepts lose a little bit of depth and get a bit denuded of meaning. And that's understandable, because that's how language works, right? We use these words in ordinary parlance. We use them in special contexts, but sometimes we lose the concept of these things as legal norms and the hard kind of the difficulty of upholding these as legal norms. So that's something that we want to kind of just bring home to people in our project. Okay. So I wanted to take you through a little, because Te Rauhī Te Tikanga, the English name of the project, refers to a Tikanga Companion. So it's the idea of journeying alongside a user of this resource. So nice little harakeke pictures up here, because I'm intimate analogies, right? But, you know, what we've been doing for the last 2 years is largely the first bit, just the gathering, and the second bit, the looking at examples of these processes and procedures in action and how they're informed by the legal norms, like seeing the connections between the norm and the ritinga and kind of trying to figure out how one informs the other. You know, when you've got an enormous amount of material and you have to winnow it down somehow, you have to be selective but not exclusive. There's choices that we have to make. I think we've utilised or surveyed, I think, 700 sources for the ritinga that we've been looking at, and I think I could have fully worked through 450 or so. So, you know, it's not exhaustive. It's not intended to be exhausted. Sorry, slip of the tongue. It's not intended to be exhaustive. It is intended to represent the functioning of a legal system. This journey that we want to bring the user on, this idea of being a tikanga companion, well, you have to organise your information first to be able to make a resource that somebody can take part in. And then we have to show examples, and we're going to look a little bit closer at muru, of muru in action, highlighting how the norms serve to drive the practices. That's kind of where we've got to. We've been getting to all that. That's a lot of the work that's in the last couple of years. Now we're at a slightly different stage, which will be finishing this year, which is to create a set of narratives, a set of tauira narratives or example narratives. Pūrākau is another word that we've used for these, which set up, which tell a story that identify for the listener or the hearer or the reader how those norms and practices are actually functioning. So often we know this because we are all members of communities that have mythological narratives at the heart of whatever community you come from. So we understand the power of mythological narratives for showing us how life is supposed to be or could be. So we're kind of creating this in a small way in our project, setting a set of pūrākau for our categories of ritinga to exemplify how those norms and ritinga work together. And then, so the tauira narratives, that's the little bit of making the kete in the middle there. And then the deeper dive scenario, sometimes we've called that a case study, looking more specifically at how the two legal systems, we've called it te tātai ture, or the general legal system, or the state legal system, and tikanga Māori as a legal system, how they contest, how they conflict, how they sometimes sympathise with each other. And so kind of carrying out case studies to examine that a bit more closely. So muru I referred to before as this idea of stripping property, taking movable property not always just property, but positions of some sort, other things as well, from people who are deemed to be responsible for something that's gone wrong. So there's categories. There are about 7 original categories, I think, for muru, but we've kind of concentrated on 4, and I'll show you what those are shortly, but we're going to concentrate in this example on the idea of muru in the case of accident. So when an accident happens, who bears the responsibility for the effects of that accident, for the harm that accident causes? There's a number of sources, and so those are just a few there up on the screen. Those are links that will take you through to the database, but I don't think I've got time to go on that little journey today. And I wanted to show you this. This is something that we adopted as part of our process very early on, because we scored, and this is controversial, right? We actually scored for each source that we examined. We gave a score in terms of the norms. So you can see around the circle, wairuatanga, whakapapa ea, noa, utsu, whanaungatanga, tapu, kaitiakitanga, manaakitanga, mana. Right? So each research assistant, and this is where some of the agonising went on, right? Have I scored it appropriately? Is this right? So there's been a lot of toing and froing, and wānanga grew out of that, yeah? For each source, each one is scored, and so this is a collation of all the sources of muru that we've looked at, and it's not the biggest category. There's around about 35 sources, right? Not the biggest, but you can see quite clearly that our researchers identified mana as being the most obviously key legal norm, but not just mana. Tapu is involved there as well, manaakitanga, whanaungatanga, but certainly mana kind of is highly important in regards to the case of muru in regards to accidents. And there's other types of muru. You'll see this is a collation. So this is all the sources that we looked at in regards to in regards to muru. And you'll see the list on the side there. Accidents, damaging a wāhi tapu, rāhui or tapu, defeat in war, incidents and disputes, land, threats to marriage. So there was like those were the original categories. And of course the one that sticks out the most, and that's because most of the sources that we had dealt with this, or the majority, is the green one, threats to marriage. So we know that muru as a response is more likely than not connected to some issue. It might be adultery, right? For those of you who've taken second-year criminal law, you'll know all about muru in the case of adultery, because we look at that, an example of that. But you can see, again, mana, preeminent, utu, tapu in regards to the breaching of a wāhi tapu, you'd expect to see that. Whakapapa in regards to the threat to marriage. Whakapapa, utu, whanaungatanga, mana. Those are the values, the principles that are most keenly engaged. This is not a scientific process. This is a process of deduction from what we read in the sources themselves. Is there anything else I want to say there? Probably not. So I've got notes, I just haven't been looking at them. Right. So I mentioned before this, like once we've kind of evaluated and scored and kind of profiled all of these sources and what they're telling us about their time and place, and not all of them are 19th century sources, right? We've got sources in the 20th century, the middle of the 20th century, and in the 21st century as well. But of course, there's more material from the 19th century. That's just the way it is. There's an element of feeling sometimes like it's a bit anthropological, but actually we still have to be looking at what people do. I guess you'd call it a form of legal realism, right? You've got to look at what people actually do in order to understand how law shapes people's behaviour. So one thing, as I mentioned before, this idea of a tauira narrative, at the base of every legal system are stories. Mythological narratives. I mean, even modern fictional works. So I dare you to read Lord of the Rings and not come out with a really clear idea of the Western concept of sovereignty. It's really clear, right? So stories matter in perpetrating how law operates and how it's to be understood. So, yeah, at the base of every legal system and dispersed throughout all kind of shared storytelling are legal narratives, or as I've put up there, key narratives about legitimacy, right? The people in power, why they're in power, right? It's a key one. This building, well, not so much this one, but the old government buildings is a fantastic example of a legal narrative, right? It tells you a story about permanence because it's made to look like it's built out of concrete. It's not. It's built out of wood, but in 1877, it was thought that to look like stone would create a sense of more permanence. But anyway, legal narrative matters, or narrative matters. And so with Carwyn's permission, who wrote us a fantastic story in regards to muru in the case of accidents, and some very quick AI image rendering by me. Yeah, apologies. I thought I'd talk you through a particular story that serves to illustrate the operation of muru in the case of accidents. All right, so you probably can't see it particularly clearly, but there's a lake there, right? So in a village near a lake lived a young rangatira. That's Kahu on the left up there. His people had lived on the lake's shores for a long time, generations. They thrived on abundant food, the resources of the lake, but not just the lake. You probably can't see, but in the back there's reference to forests, right? So these people were living on the resources, abundant resources of the forest and the lake, right? They depended for their survival on both. Kahu was married to Henewai. Henewai's people were descended from the people of the lake. So there were supernatural elements in Henewai that she was able to live in the water as well as on land. But when she married Kahu, she was able to, she gave up that power. She gave up that power to be able to live on land. Now there's lots of stories in Māori mythology. That's so my phone. Thanks, Jeff. I was in my stride. Anyway, so there's lots of stories in Māori mythology a little bit like this, right? The idea of people who are coming from people of the forest or people of the ocean. There's special qualities about these people, and that they give something up when they live with humans, and there's a consequence for that. Henewai, part of the people of the lake, they are descended from Mārohirohi, the taniwha and the kaitiaki of the lake. Over time, there's some change that starts to happen because there's other people that are starting to use the resources of the forest. So there's less food available for Kahu's people. And so they're starting to be a bit more dependent on the resources of the lake. And so they're a little bit afraid. This is a bit of a period of uncertainty and unsurety for these people because the bird life has been depleted. And their survival relies on their connection to the lake and their connection to the people of the lake. So Kahu asks Henewai to speak to her family for help to kind of shore up that relationship. She's now pregnant with their first child. For some reason she's wearing a T-shirt. And never mind. And she's been told that her child will inherit the powers of being able to be in the water as well as on land. So will inherit her powers. So ensuring that that will be kind of like an agreement for the ongoing abundance of the lake's resources for the future. So the child is born. Their connection with the lake flourishes. the lake resources flourish, the people flourish. Now, when the child's about 4 years old, Henewai goes off to visit her whānau. Kahu is looking after a visiting delegation from another hapu, looking after some rangatira that have arrived. He forgets to make sure that somebody's looking after the child, right? The child has a very serious fall and breaks his leg. And seriously, like badly, breaks his leg. Henewai returns, and of course, she's furious, and understandably so. Even though she knows it's an accident, there is going to be a consequence for this accident because of the mana of the child. And there's going to be a consequence from the people of the lake. And so the people of the lake call on Mārohirohi, the taniwha, who's this very artistically abstract rendering over here because like AI is no good at and so what happens, and you can probably see it in the background of this slide here, is that the lake floods the village and takes everything except the people. So all property, all structures, all other stuff is just washed away in an instant. Now, this looks like the end, right? This is a catastrophe. Kahu's people are devastated because now they thought, well, what is our future? How do we survive? They think about moving away, but Henewai says to them, actually, no, don't move away. This is now your opportunity to rebuild the relationship, to start a new phase in the relationship. Because as long as their child remains, the lake would provide. So the village was rebuilt. The child continued to grow. Again, the resources of the lake flourish. The people begin to flourish again, and the relationship is restored, right? And again, life continues under the watchful eye of Mārohirohi. So, of course, that narrative reveals some stuff going on legally, yeah? So we're talking here about sustainable use of resources, what happens when there is a threat to those resources. Note the adaptation that people have to switch from relying on two sources of food to the sources of food in the lake. Note the importance of relationships for survival between peoples. Note the damage to the relationships that happen as a result of the accident and how that actually threatens the survival, the future continuity of people. The preeminent kind of importance of the mana of the child. And something I neglect to mention there too is that the mana of the people has been diminished, right, as a result of Kahu's failure as a rangatira to manage the risk to this important child. So the diminution of mana is an important factor here. There's an agreement between the people of the lake and the people of the village, and they breached that agreement. There is obviously a failure of risk management, but you don't just blame the father for this. This is a collective responsibility because they allowed him to fail in that enterprise. There is the obvious relevance there of then key legal norms, and it shouldn't be difficult to kind of think about that and think, okay, well, mana is clearly important, whanaungatanga, relationships between people is clearly important, perhaps tapu because of the damage done to the body of the child, maybe other reasons as well. So you can kind of see these norms at work expressed in the story, and it's an example of a ritinga, of a practice. And it's not a million miles away from a lot of the stories. In fact, it's very close to a lot of the stories, a lot of the accounts that we've examined in our resources, in our project. So the muru itself serves a legal purpose, right? It restores relationship. It restores the nature of the agreement between the peoples. And it restores the mana of the people, it restores the mana of the whānau, it restores the mana of Kahu and their child. So all of that by the operation of one ritinga. Of course, often these things are all interconnected, so it's just to kind of separate it out so you can see it relatively clearly. But we've got an example here of negotiated survival. So that's the tauira narrative that enables us, or enables a user to be able to get a sense of what it means to see legal norms at work, what the ritinga might look like in operation, and then the idea would be that they can follow through and go into a deeper dive with other sources to look at what's kind of happened. And again, we're kind of working out what that might look like in the resource. We've got all the information, now it's a matter of making it sensibly accessible in a digital resource, because that's harder than it sounds. We could just put it in a big fat book, but yeah, we want to actually make it something for an online environment. So I wanted to just take you, how long have I got? Oh, about 5 minutes. Okay, cool. Probably, have I got 5 minutes? Okay, good. Want to take you into just a little bit of a case study or a slightly deeper dive. We don't have a lot of time to go deeply into this, but this is an example where you've got the legal systems clashing really quite painfully with each other, right? So you might be familiar with the figure of James Busby. He was the first kind of official British resident in New Zealand, deeply involved in the drafting and the signing of the Declaration of Independence, the Whakaputanga, in 1835, and also the drafting of Te Tiriti o Waitangi. So quite a key figure. Anyway, he was living at the British residence in Waitangi. Many of you may have been there. And he's got a storeroom. And in 1834, before the signing of any of these documents, so there's no English legal processes here. There's no English legal institutions. He was called the man of war without guns, right? Because he was supposed to be responsible for the settlers of the area, but had no way of making them do what he wanted. So, he was not exactly a legal institution himself. Anyway, he's got a storeroom. Somebody breaks into his storeroom and some goods are stolen. In a scuffle, some shots were fired. A splinter of wood hits Busby in the head. He's not happy about this. But also he's not happy about the immediate response of the Māori in the area, who don't seem that concerned, or at least he doesn't seem to see them as being that concerned. Eventually it's established that a rangatira by the name of Rete from Ngāti Tautahi, Angela Ballara writes about this event, was the culprit. He was eventually, interestingly, forced to cede land and compensation, right? So that is a form of, arguably at least, a form of muru. It was unusual because of the nature of what was being given over, land, yeah? Now, there were massive interhapu issues here, because even though Busby didn't see this at work, and probably the settlers didn't understand, but Busby himself had a lot of mana. He was extremely important to the Māori of the area for the access that he could bring to them for certain things, right? And so him suffering a personal injury and him having his property stolen, in Western legal terms at least, this was problematic. And so there were accusations going around. Kawati was accused of having engineered this event, and he sets out with a taua muru to avenge the very suggestion that he had anything to do with this. Titore, another rangatira from a different hapu, right, so this is all hapu in the north, offered himself, if there couldn't be this land cession, he offered himself as a slave to go on a ship to Sydney if there was no compensation by way of the land cession. So that wouldn't have happened had there not been these deep shockwaves rippling through these hapu. This was a deeply impactful event, although James Busby doesn't see or perhaps understand the implications of what's happened. He may not be alive to the things happening around him in quite the same way. So what you have here is obviously, doesn't really need to be said, but it's obviously a set of different legal understandings, right? So when you look at the tikanga Māori context, you've got a hara that's happened, the taking of the property, and you've got the personal injury. You've got norms that are going to be automatically kind of engaged, right? Something has happened, so there needs to be a response. There needs to be some form of utu. People's mana are at stake, not just Busby's mana, but the mana of the hapu, the mana of the rangatira. Kawati is feeling a bit annoyed because his mana's been impugned. You've got whanaungatanga, these connections between these hapu, are deeply affected by the accusation that they were involved. So until this issue is resolved, everybody's mana is at stake. Tapu may well be involved here as well, due to the nature of the injury, because he received it to his head, Busby did. Then there's the possibility of what processes to engage. So the proposed land cession, the ritinga of tuku, right, the cession of land. Busby wants a pana. He wants the rangatira responsible to be expelled from the community. That doesn't happen, but that's what he wants. And you've got people involved in hui talking about this. Obviously, this is very important. You've got high-ranking rangatira all exercised about this issue. You've got a taua being dispatched by Kawati. You know, there's stuff going on here. It's a bit of a tinderbox at this point. So if you can see those things at work in a tikanga Māori context, but of course it's a different set of concerns when you're looking at what the perspective of the English legal system would be. You know, Busby's lost property, so most people that have had anything to do with the Western... Not again! Most people that have anything to do with the Western legal system will know the importance of property, the centrality of property ownership. Much of Western law is based around or based on or ramifies off the need to protect property rights. We're very familiar with this. But he's also suffered a personal injury. And there's lots of kind of criminal law proceedings around personal injury. Personal injury, the harm of the person, those things are hugely important in the criminal context in the Western legal system as well, not just the criminal context. So both of these, if they were found to be crimes in an English legal system, would incur criminal sanction. At the time, probably by way of offences against the Person Act 1828 or the Larceny Act 1828, there's likely to be sanctions decided by courts, not decided by individuals connected with the proceedings, but by courts at a remove from the events outlined. So things like imprisonment, transportation, fines, those kinds of things, fines perhaps for petty larceny, but you know, bigger forms of larceny. You might get shipped to Australia. Imprisonment for 3 years for assault under the like minor assault under the 1828 offences against the Person Act. So, you know, there's a set of preconceived, pre-identified responses, legal system responses set out in legislation that's passed by Parliament, or in the context of trespass in the common law, right? But none of this is available to Busby, and he's satisfied by the land cession. But there's lots of this kind of systems rubbing up, or concepts rubbing up against each other. They're not always at loggerheads. There's actually quite, and we see that with Rauhī, for example, where the way in which Rauhī are used and how they've survived over time and actually multiplied, the use of Rauhī is much more common now, it appears, is partly because the Western legal system can understand prohibition on fishing in certain areas. You know, there's understanding that, or kind of like, I guess a sympathetic vibe that can go on between the two legal systems. Not often, but it can happen. So seeing these two, having the opportunity for users of the resource to see the tensions, to see the sympathies between the two systems, and you learn something about both as a result. So I'm coming, you'll be glad to know, to the end. There's lots to be said and there's lots more I could say, but you'll be glad I won't. But I just wanted to leave you with that image of the water, right? Because, you know, our job as law schools throughout the country, and this is the kind of law reform kind of bit, is to understand, to teach people how to understand the operation of tikanga Māori, not to become experts, not to become even vaguely competent in tikanga Māori. Law schools can't do that. But what law schools can do is to teach people to see the waters that have been hidden under their feet for so long. That's the best I think that we can that we should be aiming for, to see the fact that the system exists, to see the good things that it still holds, and to understand that it has its own integrity, and to seek to protect that integrity, even though that's hard and difficult. And there are much better minds than mine in this room that are grappling with those questions right now. But yeah, look for the waters. Ka pai. Kia ora, everybody. Thank you.
So, for those of you who don't know me, my name is Jeff McClay, and I have the honour of being the Dean of this law school. I was also supposed to be the timekeeper, I suspect. I tried with the phone. It didn't work. But truth to tell, I could listen to Māmari forever. And I probably have over the last 20 years. So we don't have an enormous amount of time, but I think it would be important just to honour that with a couple of short, sharp, incisive questions, and then we can move on to close the evening. But I think it would just be important to honour Māmari's contribution with just a few questions, if that's okay with Māmari and okay with you. If you do need to leave, you can leave, but if you're like me, you might want to listen to even more Māmari Stephens. So does anybody have any questions? Any pātai?
Yes.
Rawinia. Oh, we need to give you them.
Tēnā koe. I'm interested in how you made the distinction between retinga, between muru and utu.
Do you mean?
Well, why is muru a retinga and utu not? Or can utu be a retinga?
Well, how?
Or like, at what point did you determine there was a split between the two?
Well, I guess the way that we conceptualised it, and yeah, you can always have those arguments. We had to make decisions. The way in which we conceptualised utu was this idea of return, right? The return of something for something else. What form that took might be the retinga, but often people will talk about, he just took utu. So as a matter of ordinary usage, we don't necessarily divide things up like that. So there are all kinds of ways in which utu can be taken, or utu can be implemented. So, but we're just looking at those 12 retinga. But yeah, absolutely. These are decisions that we make, and you can always not quibble, but you can always challenge that as a decision. But that's the way we saw it. We saw it as the force of response, and what was the nature of the response? What drove that response? What did the response look like, and how did it work?
Cool. Nicole Moram.
Thanks, Māmari, for that wonderful talk. I've got an easier question, I think. I was just wondering if you'd be able to tell us a little bit more about the sources that you're using, where these stories have been, or not the story, whether that have been preserved, so that where you're finding them.
Anywhere we can. So a lot of our sources have come through Papers Past. A lot of our sources, we've got quite a few, well, not a huge amount, but some audiovisual accounts, or documentaries, things like that, artworks. What else would you say, Ria?
Original books, so some of the early manuscripts. We go from kind of Elsden Best through to Lecretia, Papers Past.
Yep.
For modern expressions, documentaries, recordings, a lot of archival stuff. But there's a real spread of sources.
Maybe just one last question. I'm just conscious of time and people might want to head away. Peter McKenzie.
Well, first I'd like to thank Māmari for a very illuminating lecture. I'll tell you why. I've got a copy, and it has a pride of place on my shelf because it's a beautiful book. The dictionary that Alex Frame and others put together on Maori legal words. I can speak very highly of it. It's helped me on a number of matters. But then I've got a question. I was puzzled by the word muru being in the Lord's Prayer, which I encountered in church.
Only if you're not
on
Catholic.
Sundays, yes. And Alex Frame's dictionary added to what you had said on terms of muru by indicating that that was the means of reconciliation or forgiveness within the Maori legal system. Now, I found that very interesting because it explained to me why those words appear in the Lord's Prayer. And I just wondered if you had a comment on that.
Kia ora, Peter. It's so nice to see you. Just a word on Te Mata Puninga, which is the publication you're talking about. That's absolutely fundamental to the project. And Paul Meredith, who's one of the authors of that text, is on our leadership team. And so we get a lot of sources through Paul. Thank you, Paul. But yeah, absolutely fundamental. And in regards to murua o mātou hara, the idea of strip away the bad things that we've done, murua o mātou hara. So the idea of stripping really applies there. But that's only the Anglicans who took up that usage. The Catholics use something I think is whakakorengia to negate.
Yes, I noticed that.
Yeah. And in that entry, one of the points they make is that idea of forgiveness is not present in any of the Pacific cognate languages for the idea of muru. Because a lot of these things, and I didn't even get to mention this, but many of these norms are throughout the Pacific, right? This is not the Māori legal system grew up here, but it has deep Pacific roots. And that goes with the language as well. So thank you for the question, Peter. Kia ora.
Right, tēnā koutou. So one of my jobs as Dean is to close these events. I often feel inadequate doing these things because often I follow something which has been amazing, and now I feel almost completely inadequate. Māmari did try and help me by trying to make it a torts lecture, which I was deeply appreciative of. But I first of all, I've got three things to do today. One is the first and important thing to acknowledge Lecretia's whānau who are here, Larry, Shirley, Jeremy, and who are not quite here in person, but I know in heart, her sister Kat in London. So I just wanted to acknowledge them particularly, but also all of her whānau. I know there are friends here who've known Lecretia, who knew Lecretia a very long time. There are people who worked on her case, even if they arrived late. Which was probably Lecretia's attitude to Andrew during her instructions of him. But her friends and who supported her very much. And I just want to acknowledge you, first of all, because today I know is a very significant day for you, as it is for me and for many people in this room. So I just wanted to acknowledge that. My second task is to thank Māmari in general, but also to thank her for this particular lecture. I was very keen that Māmari gave this lecture because of the topic and the work that was being done, but also because it was Māmari. I'm making a joke that I've had these conversations with her for 20 odd years about the nature of law. And we now feature in a whole video course about the nature of law. I do my little Anglo-Saxon thing and she does her much more wise Te Ao Māori version. But actually, they're kind of the same. And that's one of the lessons listening to this, is we live in a world where even the nature of law is being contested, and lawyers love to contest what the nature of law is. But one of the important things about the common law we study at this law school, and have always studied, is that law is not just rules, law is systems. And law is a way of thinking and a way of civilizing and a way of making us better people. And sometimes the law is misused. In this law school, certainly, you can study how it's been misused. And this building itself is an example, in some ways, of the misuse of that law. But Māmari's work and the work of her wonderful team, many of whom are here, shows you that law doesn't necessarily have to have an Anglo-Saxon or a Latin or a French name in the way we've taught, that it's no less law because it doesn't have a Latin name, that human beings are human beings and they always come with law. And I think one of the great lessons of today's talk and of my conversations with Māmari over the last 20 years has been that recollection. And we live in contested times. We live in times when people argue about what New Zealand law is and what New Zealand law ought to be. And today's lecture is a great answer, not to them. I'm not sure that some of those critics would necessarily respond as well as we might hear, but it's the response that we as scholars give to those criticisms and those critiques. My favourite piece of Māmari's work is actually an article which I think is the best, with all due respect to other public law authors in the room, the best piece published on New Zealand public law, probably in my lifetime, her Loving Excavations piece, which is, I love partly because it's a fantastic piece of research, actually trying to find out what Māori thought about the Constitution through things that Māori actually said about the Constitution. But also it's because it's an idea of what scholarship actually is in the title. And whenever I'm trying to be my better self, it's trying to live up to the work you've seen today, which is this loving excavation of a conflicted, strange past, where things in the past, people did things differently, and it's our job to try and understand what they did so that we can figure out what we might do with our futures. And that's where the reform bit is. Māmari stole my line. I was trying to link this to law reform, but we want to reform the world. It's the great Marx phrase, the point of the world is not to understand it, but to change. The point is not to understand the world, but to change it. Well, actually, I profoundly believe, and I think all of us at this law school believe, before you want to change the world, you have to understand it. And before we want to change and make our country a better place, we need to make sure we understand what our country is. So I just want to finish, if I could, by addressing Māmari's whānau, because I know this is an embarrassing event for some of you, because you don't like seeing how much loved your parents are. But I just wanted to hope that you've realised the affection that your mother, wife, family member is held by the people in our law school. Your mother, wife, fire, whatever you want to describe her as, is at the heart and soul of our law school, and I just wanted to acknowledge that in this forum. I also just need to spend a moment talking about Lecretia. Some of you may know, I think some of you know, some of you might not know, that I spent 4.5 years at the Law Commission working with Lecretia. In fact, in some ways I was her boss, but as I said before, I don't think anybody was ever particularly Lecretia's boss. And I just wanted to make a couple of reflections. There's lots you could say about those years. I just wanted to say the following. The time I started the Law Commission coincided really with Lecretia's diagnosis. That's significant for me because in the entire 4.5 years after the diagnosis, I can remember speaking to Lecretia twice about her illness, twice. The reason why it was only twice and one of them was in the context of a new medication that was enabling her to go to Argentina, was that there was travel to be done. There were family weddings to go to. There was life to be lived. And most importantly, when she came to work, there was law work to be done. And they were incredibly important things to her. And I always felt there was no point me talking to her about the other stuff because she wanted to talk about law, and she had a belief, even given the things that I know she must have been thinking herself in her head about her diagnosis and what that meant. She was committed to making the world a better place through law reform and understanding what the law is and making the world a better place through that law reform. And I just think that's why I think this lecture is an important thing. When I have my sort of dark days, I try and remember that if Lecretia could make the effort to plan about the future, then I could too. The other thing that I just want to record is Lecretia's incredible kindness to me. In many ways, I don't think the people at the Law Commission thought that I should have been or could have been or ought to have been appointed to the Commission. There's a very strange body. Basically, there's like a group of professional law reformers like Lecretia, and then these people are jetted in over the top, parachuted in, who know very little about how actually to do law reform. And Lecretia was one of a group of people who very kindly taught me what my job actually was. The other occasion she talked to me about her illness was when she asked me to support a reference to the Law Commission on assisted dying. And I just wanted to say this in this context because I said that I would not support that reference, because I am deeply ambivalent about this, and I was deeply ambivalent about the role of the Law Commission in this reform. The point of the story is not that I said no. The point is that Lecretia stood up, said thank you for your time, and then the rest of the time I dealt with her, she never ever mentioned that again. She never ever held that against me. She never thought that I was bad or wrong. She never stopped trying to help me. And again, when I tried to think of things I could do, when people have done me wrong or did not agree with what I desperately want to do, and I think she desperately wanted to do this, I got that impression. I really appreciated that kindness, that was okay also to disagree about things that are important and still be civilized, insightful, and caring in your interactions with those people. And I think I just wanted to record that. My last and really highest honour tonight is to read the following from Matt Vickers, Lecretia's wonderful husband. And it's very difficult for me to think actually of Lecretia without thinking of Matt at the same time, if I could just acknowledge that. So Matt lives in New York now, but I've been asked to read this out. And if I make it through the end of this, I'll be doing very good. So I apologise. Today is a very significant date as it marks a full 10 years since we lost Lecretia Seales, my late wife, and a woman of remarkable intellect, passion, and grace. Though I cannot be with you in person today, my heart is there as we gather to honour her memory and celebrate her enduring legacy. Lecretia's brave actions in her final days sparked a public debate, a private member's bill, a law change, a referendum, and ultimately reform to the laws that govern end-of-life practices in New Zealand. This lecture theatre, established by her friends and family, and I just add in brackets Matt, in her name, is a testament to the impact she has had on so many lives and her profound and abiding passion for the law and law reform. Lecretia believed deeply in the power of learning, the importance of community, and the value of sharing and debating ideas. I know she would have enjoyed this evening very much, and I am very grateful for the Reverend Stephens for delivering this year's lecture. Thank you for being here, for remembering Lecretia, and for contributing to this meaningful occasion. Good night.